My name is Molly Parzin. I'm the Executive Director at Conservation Voters of Pennsylvania. I'm thrilled to welcome you here to tonight's webinar. Thank you so much for joining us for Why Courts Matter, How Our Judicial System Protects Our Environment. We're going to first go over a couple of logistics to make sure folks are settled in for the program. We have enabled closed captioning, and if you would like to do that, you can look at the bottom of your screen. You'll see the word show captions. If you click that and then click the option to enable closed captioning, you should be able to get those up on your screen. If you don't see the show captions button, you may need to find the three little dots titled More and click those to see the options for captions. After the event, we'll send an email to everyone who registered with a recording of the presentation, as well as links that we send throughout and many of the resources that'll be discussed. And after you hear from our speakers tonight, we are going to have a brief Q&A session, as long as everybody sticks to their time cues. And then we'd love for you to use the Q&A function in order to drop your questions for our speakers. You can find that by clicking on the logo with a question mark along the bottom of your screen. So as questions come up, please make sure to drop those in the Q&A feature. Now, before we get started, I want to give a huge shout out to our fantastic co-hosts and co-sponsors of tonight's program, the Commonwealth Communications and their Pennsylvania Megaphone Project, also known as Comms 2, New Pennsylvania Project, Freedom from Religion Foundation Action Fund, and a very special thank you to Earth Justice Action, our core partners on this program and all of our judicial work this year. I also want to thank some of our co-sponsoring organizations across the state. Shout outs to Clean Water Action, Clean Air Action Fund, the Bear Shake Environmental Legal Services, and the Climate Action Team for co-sponsoring tonight's educational program. So, to dive into the materials here, we have four incredible guest speakers joining us this evening to share their expertise and key information with you about Pennsylvania's court system. We're going to hear from Kadita Kenner, the CEO of the New Pennsylvania Project, Ryan Jane, Senior Policy Counsel at Foundation Freedom from Religion Foundation Action Fund, Sam Sankard, Senior Vice President for Programs at Earth Justice Action, and finally, Colleen Craig, the Deputy Executive Director at Commonwealth Communications. And again, after we hear from our speakers this evening, we'll have a brief opportunity for a Q&A session. So please don't forget to drop your questions in that Q&A feature and make a note if you have a question for a particular one of our presenters. Please also keep your eyes on the chat for more resources and links that my colleagues are going to be dropping throughout the presentation. So after all that, let's finally kick off tonight's program. We would like to introduce the wonderful Kadita Kenner to get us started. She is the founding Chief Executive Officer of the New Pennsylvania Project, as well as New PA Project Education Fund. In addition to her work with New Pennsylvania Project, Kadita also co-chairs Why Courts Matter Pennsylvania, an advocacy project dedicated to safeguarding the independence of our state and federal courts and educating the electorate about their crucial role. I am so excited to pass it to Kadita to talk to us about why do our courts matter here in Pennsylvania.
All right. Thanks so much, Molly. So happy to be with you all. Thank you for the invitation. When I heard about how many people had RSVP'd, I said, let me put some perfume on for tonight, although we're here on Zoom. So happy to be with you all. All right. So let's get into this. I get to kick this off, and this is so exciting because for the first time, I don't have a PowerPoint to present. I just get to talk to you about why courts matter in this moment. And you're going to hear from all the coming up presenters about the very distinctions about what's so important about this year in our judicial elections. So why do courts matter? Well, we know something about federalism, maybe. I don't want to get too wonky on you here, but we do have a state and federal court system, and it's working for us in this moment. And we want to make sure that all the Pennsylvanians that are out there who are very powerful in this moment understand what's at stake this year and also understanding how important the courts are to our daily lives. Now, unfortunately, so many may have a negative connotation to courts. They may think about it as one of the worst days in their lives, or if you're not a fan of jury duty, you may think, oh, jury duty is not my favorite thing. But the courts are impacting our daily lives, whether we understand that or not, or appreciate that or not. And it's not just the criminal justice system or civil cases that are heard in our courts. It's all about our rights and our freedoms as well. And unfortunately, sometimes we're only thinking about the courts in that way, in that criminal context way, or civil cases, not so much about our rights and our freedoms. So I have a visual for you all if you're all watching me tonight. I don't have a PowerPoint, but I do have a visual for you to see. And that is that as Pennsylvanians, we have a constitution. We have our own Pennsylvania constitution, if you knew that or not. And it's been working for us in the Commonwealth. And I want to show you a visual of the United States Constitution in comparison and the size difference and why that matters. And it matters because the United States Constitution, this is the floor of our rights and our freedoms, right? We learned about the Bill of Rights and we learned about all the amendments in school, right? So this is the floor of our rights and our freedoms. It's the Pennsylvania Constitution that is actually the ceiling. We are granted more rights and freedoms in the Pennsylvania Constitution than we even are in the United States Constitution. And so when we think about decisions that have been made in our courts here in the Commonwealth that have been protecting our rights and our freedoms, we'd be remiss if we're not talking about those that are going to, as a voting rights organization, ensure that our voting rights are protected, that we have a free election clause here in Pennsylvania. Free and fair elections are part of our Constitution, and other decisions made by the courts throughout the years that have impacted our daily lives. I think about decisions that are going to ensure that we have clean air and pure water, because these are cases that are heard and interpretations done by our Supreme Court justices based on our rights and our freedoms. There were Commonwealth court cases, Pennsylvania state Supreme Court cases that have impacted our lives. One that may be very important to you all out there watching this evening is a case that determines um, education, public education, and how it is publicly provided to our kids here in Pennsylvania, and how their rights and freedoms are protected by the Pennsylvania Constitution that guarantees us as Pennsylvanians an efficient and thorough public education. And that was a case decided by the Commonwealth Court to ensure that that continues to happen for us. Our voting rights are impacted, obviously, by cases heard by the Pennsylvania Supreme Court and other intermediate appellate courts here in the Commonwealth. As a voting rights organization, we very much care about provisional ballots and that they're able to be counted and that your voice is heard at the ballot box. And we want to ensure that continues to happen moving forward. Now, we're just coming off of Constitution Day. It was last week. And it is really important to recognize, because so many people have no understanding that we absolutely have our own Pennsylvania Constitution and how important it is to our rights and our freedoms. Here in Pennsylvania, we're one of the oldest states, right, in the nation. We have the oldest courts. Our Pennsylvania Supreme Court founded in 1722 to ensure that our rights and our freedoms are protected. And so we want to continue to have um, the ability to believe in the justice system, particularly when there may be some thoughts about how things aren't going so well and other mechanisms, and how the legislative branch or the judicial or the executive branch or the legislative branch are behaving. But it is the judicial branch in which our rights and our freedoms are granted. And so it's so important that we get all of this great information today. And Pennsylvanians, Pennsylvania voters, you are very powerful. You're very powerful. Pennsylvania is one of only 7 states in the entire country in which we get to elect all of our judges and justices in partisan elections. Who else has that ability? States like Ohio and Illinois and Alabama and North Carolina, Louisiana, and Texas. So we join those 6 states in having the ability to elect all of our judges and justices in partisan elections. And so that makes us very powerful. It makes us very special. And I hope that in a year that typically has low engagement at the ballot box in these odd years, I hope that we have a change in the direction of going up and making sure that our voices are heard at the ballot box, because your voice matters. These courts matter, and they've been protecting our rights and freedoms. And we are guaranteed so many more with our state constitution than even our federal constitution. So I'm going to pass the baton back over it. And I appreciate everybody joining us this evening. And I hope we all have a lot of takeaways and that we're able to engage our communities, bring this information back to our communities, and ensure that we're protecting our rights and our freedoms and deepening democracy. Thank you so much.
Fantastic. Thank you so much, Kadita, for grounding us in that important information and underscoring how much power we have as Pennsylvania voters. I've always loved how you frame that. We have a big power and big responsibility here in the state electing judges. Next, I would like to introduce Ryan Jane, our next speaker. Ryan is the Senior Policy Counsel with the Freedom from Religion Foundation and the Freedom from Religion Foundation Action Fund. They do incredibly important work to keep our church and state separate. Ryan has been with FFRF for more than a decade and leads on their legislative policy team's efforts in all 50 states, including Pennsylvania. Ryan, I will hand it over to you.
Awesome. Thank you so much. And I'm going to echo some of the things that Kadita was just saying because what I have to offer are kind of a few case studies and how this actually plays out, the play between our federal courts and our state courts, and why you should care so much about state courts. And specifically, I'm going to talk about the fight that we do for state church separation, how it impacts state courts deciding individual rights, and also science-based decision making. So when we go to court to defend state church separation issues, traditionally, what we've mostly done is we would go to federal courts and argue the Establishment Clause of the First Amendment. So on the next slide, you can see on the left side is going to be the U.S. Supreme Court building. And that's what you often think of with these big state church separation cases. We go to court and we argue about the First Amendment of the U.S. Constitution. You could go to state court and make the same arguments, but there often wasn't much point because you'd be arguing the federal Constitution law anyway, and so you may as well just go to federal court. Now, the reality is that has changed dramatically in just the last few years. And this is true across many different states, but I'm going to highlight some examples that are actually from Hawaii just in the last week because they're so recent and they're so prescient. So I think if you haven't looked these up, I highly recommend it if you have any interest in these issues. So these are two recent Hawaii Supreme Court opinions that highlight the shift I'm describing, where the state courts called out the U.S. Supreme Court's assault on individual rights. And they're saying our state court constitutions can stand above these baseline protections in the U.S. Constitution. They do not have to be at the same level. And again, this is part of a trend across many different states, and I think it's a sign of things to come. So the first case that just came out last week is a case involving a religious land grant where the Hawaii State Supreme Court considered the state constitution's guarantee of state church separation, the right to a secular government, which again is separate from the federal Establishment Clause. And the court held that the state provision was a greater protection than the federal one. And there was a blistering concurrence that really tore at the Roberts Court for twisting facts and for relying too much on historical so-called originalist arguments. Hawaii's constitution, after all, was ratified in 1959, so it doesn't make a lot of sense to apply 1790s perspectives to the Hawaii state constitution. Now, by comparison, the Pennsylvania Constitution was first passed in 1776, so it is, of course, that old, but the current version was adopted in 1968, and it's been amended as recently as 2021. So we're not talking about provisions that date back to the 1790s. And then the second case I wanted to mention just today, we saw another case from the same court, the Hawaii Supreme Court, on defendants' rights to recorded interrogations. So basically, the police interrogated this guy, but they didn't record it. And the detective waited a week before writing down his report, where he said the defendant confessed to everything. And then the defendant came in and said, "No, I didn't. That's not what happened." So it turns into a he said, she said situation, but it shouldn't be because police should be recording these conversations. So the court looked at this and asked, does the defendant have a right to a recorded interrogation when they're in this custodial circumstance? And they said, once again, we don't care what the federal protections are. We have state protections that can go above and beyond that. So they ruled in favor of the defendant based on the Hawaii state constitution. And again, they tore into the Roberts Court for its judicial activism. So when it comes to individual rights, we cannot rely on federal courts. We have to take an interest in state courts because it is a crucial line of defense. And that's also true of my second topic, which is science-based decision making. So nowadays, trust in evidence-based policy is being lost, both in the public consciousness and also in the federal government. Consider, for example, the recent actions and statements by Robert F. Kennedy Jr. and his federal agency, HHS, on vaccines, on Tylenol and autism, etc., to say nothing of the president's thoughts about windmills or climate change. And courts play an absolutely critical role in adjudicating challenges to government policies that are based on these pieces of misinformation. And the federal judiciary has unfortunately been packed with people who value their personal ideologies over scientific reason. So once again, we turn to state courts by necessity. And this picture on the screen shows a recent event that we held at FFRF to commemorate the centennial celebration of the famous Scopes monkey trial. So this was 100 years ago when courts were evaluating a challenge to a law banning the teaching of evolution in public schools. And this seems like ancient history 100 years ago, but federally, we are quickly sliding back to that spot in the law. The Supreme Court correctly struck down the teaching of creationism or intelligent design in public schools in the late 60s and again in the 1980s. But now at FFRF, we're having to relitigate cases decided in the 1980s, such as whether public schools can display the Ten Commandments in every classroom. And we don't know how far back this is going to slide. So it's crucial that we have strong state court judges and justices who will stand up for both individual rights above and beyond federal protections, as well as for science-based decision making. So thank you so much for your attention. I tried to talk quickly to leave lots of time for other speakers, so that's what I've got for you today.
Thank you so much, Ryan. It's so interesting to hear about that interplay between the state and the federal courts on so many issues that I know we all care about. Next, I'm so excited to introduce Sam Sankar, the Senior Vice President for Programs at Earth Justice Action, who's going to dive in on environmental law with us. Earth Justice Action is building a movement that defends the environment and public health and ensures the laws that protect us remain strong and effective for future generations. Sam oversees advocacy strategies on issues including environmental justice, biodiversity protection, and the energy transition. Sam also serves in his role for Earth Justice, the 501(c)(3) sister organization of Earth Justice Action. And Earth Justice is the nation's largest public interest environmental law firm with 230 lawyers across 15 offices. Sam, I'll hand it over to you.
Thank you so much. Uh, I am going to turn 55 years old soon, and I'm about the same age as most of our nation's environmental laws. So we all think of environmental law and the idea of environmental litigation as being something that has always been there, but it's just not true. Most of the laws, the federal environmental laws that we rely on, you've heard their names, things like the Clean Water Act and the Clean Air Act, those things were passed in the early 70s, and they contained something that was revolutionary at the time. They gave regular people the right to sue to enforce them. So what they said was these aren't just like criminal laws that only the government can enforce. These are protections that are afforded to every single person. And that means that if you see a company down the street that's polluting in violation of the laws, you can go and sue them yourself. And importantly, if the government is issuing permits or making decisions that violate the environmental laws, you can sue the government as well. So that is the essence of what has created the ability to have federal environmental litigation. And it's been the source of a lot of protections for everybody. I think everybody in Pennsylvania and everybody on this call, whether you know it or not, you've been influenced and your environment is protected by laws like the Clean Water Act and the Clean Air Act. And those laws were brought to life over the last 50 plus years by people who litigated, by people who went to court and sued the government and sued corporations to enforce them. So Ryan and Candida have told you a story about what's happening between the state and the federal government, and I'm going to reinforce that story here because in the early days of these federal environmental laws, we had a Supreme Court that was reading them in a robust way and working with federal agencies like EPA and the Department of the Interior to build out this kind of robust network of environmental protections and broad understandings of the way these laws would work. That has been changing over the last 10 to 15 years. The modern Roberts Court, and we can go to the next slide, has started to claw back the advances that we've made in those generations. So there's a couple of these are some case names, but I'm just going to tell you what the basic thread here is. The modern Supreme Court's doing a couple of things. Number one, it's narrowing the scope of those laws. It's taking laws like the Clean Air Act and the Clean Water Act and reading them more narrowly. The second bullet up there is Sackett versus EPA. This was in a really important case about the Clean Water Act, in which the Supreme Court said, you know what? We used to say that wetlands were protected under the Clean Water Act because, after all, it's very difficult to protect the waters if you're not protecting the wetlands. And after all, it's also impossible to tell where the water ends and the wetlands begin. But the Supreme Court, the new Supreme Court, said, no, we don't want to protect wetlands, and we're going to take away those protections from the Clean Water Act. And that meant that we had a significant retrenchment in the Clean Water Act, and we have less protections now than we used to. The other thing they're doing, in addition to narrowing the scope of these laws, is they're making it harder for agencies like EPA to protect us. So, one way they're doing it is by saying that agencies don't have the authority to read these laws with the technical expertise and legal expertise that they've acquired over time. So instead of an expert scientist or agency official at EPA saying, well, this is what the law means and this is how it works, the Supreme Court has said we're going to have generalist federal judges who haven't really been steeped in the regulations or the laws themselves. They're going to be the ones interpreting how these laws can work, even if they're only getting familiar with them during the course of an individual lawsuit. They're not going to anymore defer to the wisdom and the expertise of the agency. They're going to inject their own views into this. And many, many commentators, even Justice Scalia once upon a time, said, no, this is nuts. You don't want to do it this way. We have experts in agencies for a reason, and we should be listening to them. The other thing they're doing to agencies is they're making it much harder for agencies to be independent. You may have heard recently the Supreme Court is very interested in whether Donald Trump can remove the heads of these agencies. And you might think of it as being something about the Federal Elections Commission or the National Labor Relations Board, but it also relates to environmental issues because FERC, one of the most important agencies from environmental perspectives because it regulates energy, is an independent agency. And so when Donald Trump says we want to manipulate the composition of that, that can be very important to have that independent agency. The last thing, again, that the Supreme Court is doing is it's rewriting our environmental laws from scratch. Seven County Infrastructure Coalition, a long and weird name, is a case about NEPA, the National Environmental Policy Act. That's a lot. It's the look before you leap law. It means that the federal government is supposed to study the impacts of things before it actually does them. So, for example, if you decide to build a giant detention center in the Florida Everglades to take thousands of people, migrants, and house them, imprison them there, you need to actually first consider what's going to happen to the Everglades if you build this giant facility. But the new Supreme Court is saying, well, we're not going to read that law the same way. It's going to be a much more limited set of requirements. So that's what's happening at the U.S. Supreme Court. Why does that matter for us to talk about here and to talk about state courts? Because you can do more in states. Just as Khadija and Ryan said, state courts are very important. And let's go to the next slide. In Pennsylvania, it's particularly important because Pennsylvania has an environmental rights amendment. That is this special thing. I'm going to actually read it to you. I love reading the laws. The Pennsylvania Environmental Rights Amendment is not legalese. What it says is the people have a right to clean air, pure water, and the preservation of the natural, scenic, historic, and aesthetic value of the environment. Pretty straightforward. They're the common property of the people for generations yet to come, and the Commonwealth has to conserve and maintain them for the benefit of all the people. This is super, super straightforward stuff and really important for courts to bring to life. And so this is not something that every state has. It's one of very few states. The Pennsylvania is one of very few states that has this provision built into its constitution and makes it the role of the state to be the trustee of the environment. Most states don't have this. It's a special luxury that the people of Pennsylvania afford. But it's not a luxury that's just automatic because these are words on paper. They take judges and legislatures to bring them to life. And up until 2013, this environmental rights amendment was largely a dead letter. The courts weren't really taking it seriously or doing much with it. But in 2013, the Pennsylvania Supreme Court issued the Robinson Township decision, in which it struck down some laws that were making it very easy to frack all over the state and limiting local control over that. So the Pennsylvania Supreme Court looked at the Constitution and said, these words actually seem to mean something, and we're going to bring them to life. And that has continued to progress. In 2017, there was a case involved Pennsylvania EDF versus Commonwealth that further built this out. So this isn't just an abstract idea. Our sister organization, Earth Justice, actually makes use of this environmental rights amendment all the time. So, for example, you all know that your electricity and your gas, the prices you pay and how you get those things are regulated by the Pennsylvania Utility Commission. Uh, you would think, how do I have input in this? Well, the way you do it is the utilities like Philadelphia Gas Works, put in proposals to the Utility Commission for how they'll get paid and how they're going to build out their infrastructure. And for a long time, they argued that people like you and people like our clients and our partners weren't allowed to participate in those proceedings. We argued that we were allowed to participate in those proceedings, in part because of the Environmental Rights Amendment. And that allowed us to start participating in them. And that makes a difference. So, for example, in recent proceedings in front of the Utility Commission, the Philadelphia Gas Works put in a proposal with a huge amount of plans for extended build out of gas infrastructure and a significant rate hike. By intervening in that and by participating in it, we were able to get a 40% rate reduction and guarantee community participation going forward. Same deal on the electric side. We were able to recently work with PICO, be able to intervene in a utility commission proceeding and being able to make sure that long-term solar contracts were something that the utility used and that customers were going to get lower prices. It really matters to have things like this. A last example, there's Scrubgrass Power up in Kennerdale, Pennsylvania. This is a coal-fired plant that largely exists to burn waste coal for cryptocurrency generators. This is about the worst idea possible. You're burning the worst fuel for a very very limited value. And in doing that, they were generating this huge pile of coal ash that we wanted to deal with because that coal ash was leaching into the water, and the power plant actually was the subject of a lot of violations, and the Pennsylvania DEP actually took action against it, but it did it very weakly. And only by getting involved in that case were we able to tighten up the settlement, strengthen what happened, and clean up the coal ash. That's the kind of case that goes to the state courts if it gets appealed. And so if we hadn't settled that case, we would have ended up litigating it in front of the Pennsylvania Supreme Court eventually. So this is something that's very live for our sister organization, Earth Justice. We use the state laws, we use the federal laws in state court constantly. Just as a couple more examples, right now we're representing Marple Township, challenging the PUC's approval for more gas infrastructure. The utility claims it doesn't have to look at greenhouse gas emissions or the impacts or the alternatives. And we're saying it does under the Environmental Rights Amendment. That's a case of first impression. It's currently in the appellate courts. It almost certainly will reach the Pennsylvania Supreme Court. Again, the composition of that court will matter. Similarly, we've got cases involving the new Homer City proposed gas plant, which will be the largest gas plant in the nation, dedicated in part to serve a data center. We're working with Penn Future, Clean Air Council, Sierra Club, putting comments together on that. If there's a permit issued, again, that goes up through the state courts, and that could end up in the Pennsylvania Supreme Court. I want to close by doing something that's very important for us at Earth Justice Action and to our sister organization, Earth Justice, and that's to thank all of the various organizations that we work with, the partners that we have that allow us to help do good work in the state. Thank you to all of you, and thanks to everybody who's attending this call.
Sam, thank you so much. That is absolutely fascinating, fantastic overview of all the incredible work your organizations are doing, ensuring that we're holding polluters accountable and defending our environment through our judicial system. I want to take a moment and build on that, and I would be remiss if I didn't mention the incredible legal team that often partners with Earth Justice at CVPA's strategic partners, Penn Future. They do a lot of litigation on behalf of the environment at the state level as well, and I want to mention a few quick examples of their legal wins that demonstrate how, for even further, how the judicial system is a critical avenue for environmental protection. Some of the work that they've done has been through the Environmental Hearing Board, which has jurisdiction over appeals of decisions made by the Department of Environmental Protection. And Penn Future's lawyers, via that venue, have helped halt the expansion of multiple fracked gas facilities and infrastructure throughout the state. Penn Futures lawyers have also worked to advance sustainable development and protect our watersheds through several cases they've worked on related to distribution centers and warehouses, an increasing and growing problem here in Pennsylvania and in a number of other states. And last but certainly not least, a case that I'm sure many of you have heard about, Penn Futures legal team has been working hard on the Pennsylvania Carbon Capture and Trade Rule, also known as RGGI, the Regional Greenhouse Gas Initiative. They've been arguing this case in front of the Pennsylvania Supreme Court and arguing about the harms that climate change and greenhouse gas emissions have on all Pennsylvanians. Having reviewed that important litigation that's happening at the state level with our partners at Penn Future, I'd like to introduce our final speaker, Colleen Craig. Colleen is based in Philadelphia. She's the Deputy Executive Director at Commonwealth Communications. Originally from Youngstown, Ohio, don't judge her too much for being from over the border. She has over 10 years of experience in communications and digital organizing for campaigns, ballot initiatives, and political organizations. And I'm so excited to pass it to Colleen now to tell us more about how do we actually elect our judges in Pennsylvania.
Thank you so much, Molly. I am thrilled to be with all of you here tonight. As Molly said, my name is Colleen Craig, and I'm going to talk to you tonight about how retention elections work. If you're unfamiliar with that term, don't worry, we're going to get right into it. But this is an excerpt of a presentation that we've been doing with all sorts of partners and volunteers in our Pennsylvania Megaphone program called Pennsylvania Courts 101. So we'll talk about the retention elections and why these courts matter so much. Next slide, please. So on this first slide, on the left side of the screen, there is a diagram that shows what our courts system, the structure of our court system here in Pennsylvania. At the very bottom, you can see all of the local courts that we have. So there's the Pittsburgh Municipal Court, Philadelphia Municipal Court, and then all of the magisterial district courts throughout the Commonwealth. Right above that, we've got the Court of Common Pleas. Above that, the Commonwealth and Superior Courts. And at the very, very top, we've got the Pennsylvania Supreme Court. Now, all of these in 2025, as Kadita said, we as voters in Pennsylvania have we have a lot of power to wield in deciding who sits on these courts and who, how those individuals may impact decisions that come out of the rulings on these courts. So, from the important thing to take away here is, you as voters have a lot of say and power more than folks in many other states. And these courts, as we'll talk about tonight, really do impact not just environmental protections, but all sorts of issues from economics to healthcare to our basic rights and freedoms. So you'll see judges on all levels of these courts on the ballot this year. And the one that I'm going to talk to you about most in depth tonight is that Pennsylvania Supreme Court at the very top. Next slide, please. So, what is judicial retention? Well, it's in short a quirky election that has major stakes for Pennsylvania. And so let's go to the next slide and talk about what this looks like. In 2025, in November, you're going to see the names listed here on this slide on your ballot. I absolutely encourage everybody to do your research about these judges and justices, learn about their backgrounds, so that you feel informed to make your choice if you do vote, when you vote. But tonight we'll make sure to provide you with some voter guides also to read more about specifically how the PA Supreme Court and these justices on that court have some decisions that have come from the PA Supreme Court in these last 10 years. And on the next slide, we'll talk about the mechanisms of how retention works. So in Pennsylvania, judges on the Pennsylvania Supreme Court are elected to what are technically lifetime terms, but they are subject to a retention vote every 10 years, or in other words, a vote of whether or not we want to retain or keep those judges on the bench. Um, I'll also add a lifetime term up until the age of 75. So there is an age cap there. But every 10 years have the power as voters to keep or change the current court. You can see on the right side of the slide here, how this looks on your ballot. And I have another diagram that you'll see on the next slide, which we can go to now. So in the most simple terms, a retention election is a yes or a no vote for whether you, as a voter, want to keep a judge on the court or not. So if a justice receives a majority yes vote, they will maintain their seat for an additional 10 years. And if a simple majority of voters votes no, that sitting justice would then be removed from the court. Um, we will talk about, why this is challenging for voters. There are a few different challenges in an election like this. But part of why we are holding this call tonight, part of why we're talking about the retention process is because a lot of voters don't even know that this election is happening, and we want everybody to have the opportunity to feel informed in these choices that they make, and also to illuminate a little bit about how these retention elections work, 'cause most folks are not familiar with how those operate. So, if if a justice is removed from the court, if a majority of voters vote no, then a partisan judicial election would take place to fill the seat in 2 years. And until that time, their seat would be made vacant unless an appointment was made, which in the case of Pennsylvania's political makeup at the moment is unlikely. We think we'd be likely to, if all things remain the same, we would likely see just a stall in those seats being filled. So would then in 2027 head towards a partisan judicial election as opposed to a retention vote. In that 2027 election, there would be two candidates on the ballot, whereas in 2025 for a retention vote, we only see the one sitting justice's name with a yes or a no next to it. Next slide. So I mentioned that there are some unique challenges for voters in Pennsylvania on participating in this election because a retention vote is not something that most folks are familiar with, and so those challenges are that these judicial races are usually buried on the ballot. So you'll often find them either on the very bottom or on the back of your ballot. And so if you don't think to flip your ballot over and vote all the way down, you might miss them entirely. This is something that commonly happens. In fact, in judicial retention elections, we see a lot of voter drop off of folks not finishing their ballot. So this is also placed after all of those head-to-head matchups at the county or local level. Secondly, most voters don't think about the courts in their day-to-day lives, or or understand. Those of us who do not work in the legal realm may not understand the background or the nuances of this choice. These are really not elections that are top of mind for voters. Thirdly, voters are used to picking between two candidates from two parties, whereas in this instance, they're seeing only the name of the sitting judge without naming their party affiliation on the ballot. Again, it's just that yes or no vote. And then finally, this is something I really want to underscore. The Pennsylvania Supreme Court is not the U.S. Supreme Court, but the Supreme Court that most folks are familiar with is the one at the federal level. So this is a point of confusion often for folks that once you do explain what the difference is, that there is a difference between these two courts, it actually I think creates a good an effective way to explain what the Pennsylvania Supreme Court does. So, but without that, without knowing that at the top, it is another sticking point where voters may feel like they don't have enough information to participate or may feel confused. Next slide, please. Finally, I mentioned that we do have some nonpartisan voter guides that we can point you to if you're interested in learning more about the judicial retention races. You can go to guides.vote, or you can look up what's going to be on your individual ballot at vote411.org/ballot. And there is also a resource from the Pennsylvania Bar Association, which is a nonpartisan association that gives recommendations on which justices they recommend. And so that is another nonpartisan resource for you to check out. And I want to thank CVPA so much for having me join tonight, and happy to answer any questions during Q&A.
Fantastic. Thank you so much, Colleen, for all that incredibly helpful information. I think there's a number of great follow-up questions in the chat that we will try and address next about how you make some decisions, how do you know who's on your ballot, how do you evaluate them, etc. Folks, don't forget all the resources that our speakers have referenced have been dropped in the chat for you to access. We'll also send them in a follow-up email to you next week. And so we're going to turn with 15 minutes left. I cannot believe that we are exactly on time today, which is amazing. We're going to turn to our Q&A function. Thank you so much to everybody who submitted phenomenal questions. Before we do that, I do want to highlight some of the final takeaways from our speakers tonight. Our judicial system, as so many of our speakers have acknowledged, is a critical backstop to protecting our rights, including our right to a clean and healthy environment and our rights to vote. Here in Pennsylvania, we elect our judges. Judicial elections happen during odd-numbered years, like this year. These judges will be on your ballot this November. Whether you vote by mail, whether you go in person, you will see judicial elections on your ballot. So mark your calendars to vote on Tuesday, November 4th. Now, turning to the Q&A, we apologize we are not going to have time to answer everybody's questions, but we absolutely will follow up with as many of you as possible, and we're going to try and get to some of the questions that we saw coming up again and again this evening. So first of all, David and others, folks who have asked questions about specific environmental bills, we actually will talk briefly about some of those in the upcoming ways to support environmental legislation at the end of this webinar. You can also follow up with conservation voters of PA specifically about legislation that we didn't cover, and we would love to talk to you about those bills. So this first question is for Sam. Sam, Carla, and some others in the Q&A asked how we can strengthen the Environmental Rights Amendment here in Pennsylvania. There's also concern and curiosity about how some of the things happening in Pennsylvania, like fracking, are allowed to continue with this amendment in our Constitution.
So there's good news and bad news. One is that amending the state constitution would be a challenging process, and I don't happen to know exactly how you do it. I see Kadita nodding. Maybe she's already got an amendment plan. But the words on paper, as I read them to you, are strong, right? They're there. So how do you strengthen it? You strengthen it through getting court decisions that interpret it in the positive ways. Just like we have rights in the Bill of Rights that everyone knows about in the federal Constitution, those laws get brought to life through decisions where a Supreme Court interprets them in a more and more expansive way. That's already happening in Pennsylvania and happened in those decisions that we talked about. So it's a matter of making sure that we have a strong Pennsylvania Supreme Court that continues along this trend. As far as what is this, why is it that bad things happen in Pennsylvania despite this strong language? Well, there's a couple answers. Number one, again, the words are important, but the interpretation and the application of them is what judges do. So just the words on paper aren't enough always to prevent all the things that we might not want. And we don't have a legal system or a world in which we prevent people on private property from extracting, in most cases, the natural resources underneath them. So fracking often happens in Pennsylvania on private land or on state land where people are accessing the resources underneath, and they have to do so in accordance with lots of laws. So, for example, even though you are able to access frack gas, you have to follow certain rules about how you construct the well. You have to follow rules about how you take the materials out and transport them safely elsewhere. You have to follow rules about how you clean up the areas after you're done. Now, many of these rules are rules that oil and gas companies don't always want to follow. They can be expensive, they can be time consuming, but that's where lawyers come in, and that's where lawsuits come in, and the ability to go to court matters.
Thank you so much, Sam. David and Daryl and a number of others in the chat had some questions about the case you raised, Ryan. So we'll go to you next. They asked for some clarification on how state courts can have a more important role than the federal courts. In particular, folks were wondering about what happens when a good state court decision is appealed up to the federal courts. Can they then rule against that decision?
Yeah, it's a great question, and there's a whole body of case law on it, but the short version is that if the state Supreme Court's decision is based entirely on state law, then usually you are not allowed to appeal that to the U.S. Supreme Court. The U.S. Supreme Court is not allowed to come in and say the Pennsylvania State Court interpreted the Pennsylvania Constitution wrong. The Pennsylvania State Supreme Court is the final arbiter on what the state constitution means. The only way to really get around that is if the side that wants to appeal is able to make an argument that the state Supreme Court ruling somehow violated their federal rights. So Brown v. Board of Education is an example of this playing out correctly, where you had states that were violating people's rights, and that those state court decisions were able to get appealed to the U.S. Supreme Court to step in and protect kids' rights to go to public schools. And so the argument on the other side of these cases, for instance, would be if you can make the argument that the state Supreme Court's decision violates my, say, free exercise of religion right, then maybe you can get the U.S. Supreme Court to listen and rule on that specific defense. So in some of these cases, though, if the defendant is the government, for instance, they're not going to be able to argue that they have free exercise rights. The government doesn't have protections under the Bill of Rights, for instance. So usually in a lot of these cases, it's just not even in the cards. The state Supreme Court is the final decision maker, and that's it. When you see exceptions, it's because of some sort of reasoning like that, where they're evoking a federal right under the Bill of Rights, usually.
Absolutely fascinating. I actually did not know that. Sam, we're going to go back to you quickly for a very timely question. If the EPA revokes its climate change endangerment finding, as folks may have seen is under discussion, how would that impact the use of Pennsylvania's Environmental Rights Act to limit climate pollution in Pennsylvania?
Whoa. Good question. So I spent the entire week at Climate Week up in New York City. I just got back in time to do this call, and everybody's talking about the endangerment finding, and literally nobody asked me that question. So let's see. So the endangerment finding is for those of you who aren't paying attention to this, is the sort of predicate scientific finding that EPA, scientific and policy finding that EPA makes to determine that it needs to do something about greenhouse gases under the Clean Air Act. And ever since 2009, I want to say the EPA has concluded that it does need to do that. And the Trump administration is trying to revoke that finding and say, no, greenhouse gases aren't covered under the Clean Air Act, and we don't want to do anything under it. So what that finding does is it enables EPA to act under the Federal Clean Air Act. To the extent that Pennsylvania agencies very often implement federal laws. So as Khadija said, we have a system of federalism, but in our system of cooperative federalism, very often it's state agencies that are implementing laws like the Clean Water Act and the Clean Air Act. So it wouldn't be at all surprising if revoking the endangerment finding would change the way that Pennsylvania state agencies like the DEP would be able to do their job. but it wouldn't impact the Pennsylvania Equal Rights Amendment. The Pennsylvania Equal Rights Amendment is a parallel and independent provision by a sovereign state about what it believes, and that environmental right amendments governs everything that happens in the Pennsylvania government. So if the federal government is doing all kinds of crazy stuff on the side, it would be tricky to say that the Pennsylvania ERA forbids the federal government from doing that. That's the supremacy clause. So the Pennsylvania Constitution can't limit the federal government's actions, but that's a good thing too, as Ryan suggested. It allows the state to do its own thing when the federal government isn't pointing in the wrong direction. Long answer. That was partially because I was stalling to figure it out in the very beginning there.
I love watching lawyers talk and think at the same time. It is fascinating and terrifying how so much of this is being worked out in real time in the new world we're living in. Um, Andrea, Yvette, and a number of others asked a lot of important and fantastic questions about the retention election, specifically on this year's ballot. And so I would love to turn to Colleen and or Kadita to answer a couple of questions here. First of all, how many judges serve on the Pennsylvania Supreme Court? First of all, I can actually answer that one. So seven currently, and three of them are up for retention this week. But could either or both of you remind folks when the election is, where folks will find the retention elections on their ballot? And can you give a little bit of clarification around whether these justices are retained? Does that mean that the next retention vote is in another 10 years from now?
I'm happy to take those questions. Absolutely. So, these races, all of the judicial races will be, the retention races will be after the head-to-head partisan matchups on your ballot. So you'll see these either at the very bottom of the ballot, or you may need to flip your ballot over, to find them. So, as I said, it's common that we see a lot of drop off of voters not completing their ballots in retention elections. And that is partly because of the placement of where these races are on the ballot. So make sure to vote all the way down, flip your ballot over, make sure you voted all the way down to the bottom. And on the other question, yes, I believe the answer is correct. So if we vote to if these justices are retained, if a majority of voters vote yes to retain these justices, they will serve another 10 years on the court, unless they reach that age cap of 75, at which point I would have to defer to one of our legal minds on the call to talk about what happened there. But yes, and typically they would be on for another 10 years. I don't know if anyone else would like to complete that answer.
I can add on a little bit there, Molly.
Yeah, that'd
That's
be
right,
great.
Yeah, that's great, Colleen. Yes, so Molly, you were absolutely correct. Seven Supreme Court justices on the Pennsylvania Supreme Court compared to the nine on the federal Supreme Court. What's so important about this year with three vacancies, potentially, if judges are not retained, that would leave four Supreme Court justices on the bench and give us a bare quorum. The likelihood that the Pennsylvania Supreme Court would be able to make any types of decisions in the next 2+ years, awaiting a 2027 election in November, where judges would not be placed until January of 2028. That's a lot of years that has an opportunity in which the Pennsylvania Supreme Court is unable to make decisions for us. I would say justice delayed is justice denied. In terms of terms themselves, it only is for the Court of Common Pleas, the Commonwealth, Superior Court, and the Pennsylvania Supreme Court that has 10-year terms. And so if you do see retention voting on your ballot this year for the magisterial courts or municipal courts, those are a 6-year term. And so, yeah, the three Supreme Court justices on the ballot this year were all elected in 2015 in partisan elections. And now this year is the retention for an additional 10-year term.
Wonderful. Thank you so much, Kadita. So we are running short on time here, but I did want to acknowledge, as several folks mentioned, that it can be really challenging to find opinions on policies from the judges. Where do they stand on the issues? How do we decide who to vote for? We are going to send a lot of resources about that tell you how these folks have voted in the past, how they have ruled in the past, that will help you make your decisions this November. So please do keep an eye out for that. We just don't have time to cover it tonight. So we have one final question here that came up time and time again in the chat. Sam, so many folks tonight asked how we can protect the things that we love, like our forests and waterways, or protect against things like developments and AI data centers coming to their hometown. Could you talk to folks a little bit on the call about how they, as individuals, as Pennsylvanians, can help use the justice system to protect their environment, or can perhaps support the organizations that do so, just like Earth Justice?
A couple of things. First of all, we have a democracy if we keep it. And keeping it requires using it. It's like a muscle. And democracy starts with people power. That's the root of that Greek word is it's people. So the most important thing we can do is in these times to stay active, to stay on our front foot and to keep our voices loud and clear. So if you've got something that's happening in your area, whether it's a project or something like that, write letters, talk to your elected representatives, be active in the electoral process, whether that's of any kind. And then get active in groups and NGOs like the ones that are on the screen right now that pay attention to your issues. Learn from them, support them if you can financially, and they'll often connect you to resources that'll allow you to amplify your voice and join theirs. Um, and last of all, I think that when necessary, be out there, be visible, right? Right now, in these days, democracy is under attack in so many ways. It's important for our faces to be on the streets and to be clearly in opposition to the things that matter. I am so glad. It makes me so thrilled to see so many people on this call because it lights a fire under me to do a better job and to keep fighting for what we believe in.
Thank you so much, Sam, and all of our panelists for answering these questions. If I could have your attention for just 2 more minutes while we have you here, we do have some final calls to action to answer that question of how can you get involved? How can you make a difference? First of all, you can sign up to stay up to date on critical information about our courts, about judicial elections, about decisions that our courts are making. It's a really easy website to remember. PASupremeCourt.com. Earth Justice and Conservation Voters of PA will be keeping that updated throughout the year with critical information. Second, we have some amazing organizations that hosted tonight's event, and you should keep an eye in your inbox for easy actions you can take with those organizations to advocate for issues you care about, including environmental protection. Also, be sure to let your friends know about the importance of the court system and how critical it is to protecting our rights. And most importantly, don't forget to vote on Tuesday, November 4th. If you are requesting a mail-in ballot, do that. If you're going to your polling place, make a plan to go vote and make sure to tell your friends and neighbors to do the same. Now, if you want to go above and beyond, we do have two opportunities right now we're further highlighting to protect our environment on the legislative level right here in Pennsylvania. First, there is a critical environmental justice bill in the legislature right now. This would ensure that the Department of Environmental Protection here in the state considers the entire cumulative impact of polluting facilities when considering whether a new facility is going to be given a permit, not just the individual pollution levels from that facility. And this is so important for communities that have been historically overburdened by pollution. So that is HB 109, and we have a great action alert. We're going to put it in the chat. We're going to send it to you in an email. We would love to have you sign on to that one with us. And next, we would love your help in helping us push for clean, reliable, and affordable, emphasis on affordable energy by telling your lawmakers to support House Bill 501. This is a great bill that's going to push Pennsylvania to produce 35% clean and renewable energy by 2035. This is well past the absolutely abysmal 5% right now of renewable energy that we produce in this state. We need your help to get there. Please sign this petition to urge our lawmakers to advance this legislation and get this on the board. We deeply appreciate each of you for joining us this evening and taking the time to learn about the ways to protect our environment through our judicial system and how our judicial system plays a critical role in protecting all of our rights and protecting our democracy. Thank you to each of our co-hosting and co-sponsoring organizations. And again, please be sure to keep an eye on your inbox for the recording of tonight's event as well as the resources we shared. Thank you for taking time out of your busy days to join us and have a wonderful evening.